In this episode, we will talk about the nuts and bolts of the family justice system. And today, my guest is Monica Garvey. Monica and I have had parallel careers, myself as a solicitor and Monica as a social work professional and latterly a mediator. We first met in the 1980s, so we've had a long time in family law. Monica was a probation officer, then a family court welfare officer, a CAFCAS officer, and now is a family mediator with her own mediation practice. Welcome to Opening the Door to Family Law, Monica.
Thank you for the invitation, Mike.
And it's lovely to see you.
Lovely to see you again.
It's been great working together over all of the years, and things have developed and changed, but a lot of things have remained the same.
Yes, indeed.
One of the things that I like to know from our guests is, what was it that brought them into the family justice system, into the area of family law, helping people to resolve disputes?
Okay, well, as you've outlined, Mike, I started as a probation officer, and back in the day, they had governance over the family justice, our role in the family justice. So I volunteered to become a CAFCAS officer. And I practiced as a CAFCAS officer and as a children's guardian for 10 or 12 years.
And just interrupting for a second, not everybody will know what CAFCAS is or
Indeed.
what CAFCAS stands for.
Children and Family Court Advisory Support Services. Used to be known as court welfare.
Yeah.
So the role of the CAFCAS officer is to be an officer of the court and the eyes and ears of the court. If you think about it in the court setting, the judge has access to the applicant, solicitor or barrister, counsel, and the other parties,
The respondents.
Respondents. But they don't have a neutral, independent voice who is there to represent the child. And the judge has to always, in accordance with the Family Law Children Act, as we all do, has to put the child at the forefront of all the decision making.
Yeah.
So they rely upon a CAFCAS officer very extensively to go and investigate and ask the questions that they want the answers to.
Yeah.
And then to give a report back to the court, which can then be diced and sliced in the witness box by all concerned, so that it can assist the court in reaching its decision.
And what made you, because people think probation, that's to do with criminal law,
Yes.
But the probation service also, criminal probation officers also dealt with family matters.
Of course.
Yes. What was it that moved you towards family work rather than crime?
I think I wanted to try a different area of social work. I found the area of family conflict and dispute a very interesting area, because I had ideas about how one might resolve conflicts.
Yeah.
And my sort of philosophy, and I suppose it's why mediation attracted me, having witnessed so many contentious disputes that can get stuck in the court for literally years. It was always my feeling is that surely there's got to be a quicker, cheaper, better, easier way, possibly earlier on, before these problems become so huge that people cannot find their way back.
Yeah. Just on that point, I often used to say to clients who came in to see me as they were just taking a seat in my office, I'd point over the shoulder and say, and they'd look at me a bit puzzled, I say, there's the door. It's not too late to go back out. And again, they'd be a bit shocked. Well, first of all, a solicitor saying that they didn't want the money from their pocket. But I would say to them, once you become involved in this system and in these proceedings, things will change. What's your experience of that? The dynamics, the shift in dynamics in relationships once proceedings start?
Well, everybody loses control. Well, apart from the professionals might do sometimes as well, thinking what we're going to do with this. And I think similarly, Mike, I often say to people when they come to me, just to give a sort of an overview, in the system, you only ever have one of two ways of sorting this dispute, whoever you are, whatever it's about. And it goes like this: either you two agree something, and then we can formalise that, or the court decides. And I suppose, returning to your question, once the court decides, or you go down that avenue, you lose control. And I think that comes as a tremendous shock to people, because we live in a world of choices. We're consulted all the time about how we might like it. Would it be this way, that way? The court setting is extremely formal, and nobody is interested in, particularly in the parents. That's probably a bit strong. They want to know what the parents think, but their focus, it could well be very different. It will always be about the child and their idea of what is fair and what is right and proper, which may or may not chime with the parents. That's just lucky dip. So I think, we quite frequently hear in court judges who are exasperated with parents saying, I'm not interested in what you think or what you feel. My only concern is the child. Yes.
One of the things that occurs to me at times during proceedings is when a judge says that, how it makes a parent feel.
Well, I imagine very angry, disempowered, and the frustration with having to, that they've lost control and they're paying for it as well, and it moves slowly. In order to sort of try and explain it to people, I like to say, look, try and get them to see it also from the court's point of view. The courts, the family courts, are like the intensive care system of a hospital. They want to see their emergency patients. They will deal with you if you've got a poorly finger or something, if they're forced to, but they will be irritated and they won't want to give it the time it deserves. One of the beauties of mediation, if people are minded, and it is about an attitude of mind, and whether it's not for everybody, it's not the panacea, but for a lot of people it can be, that it gives them options and it allows an opportunity for them to explore a balanced approach that is child-centric, that is also works for them, and it will afford parents that ability to go into the minutiae of how they want it planned and run for their children post-separation. And also critically, I feel very strongly about, particularly in children's disputes, I always say to clients, look, there are two aspects always that will make a contact for children good, and it's broken down into two areas. The first is you have to have the good mechanics, the what, when, how. And that's something that parents understandably are always very, very preoccupied by. And they want as many hours, you can't blame people of the day, and they're counting it out, and they want as much as they can. But there's another massive part, and that's the bit that the children are preoccupied with, and that is the spirit of the contact and how that works. Because you can have the best court order in the land, forged by the best KC going. But if two parents, after the ink has dried, are prepared to going to sabotage that in 1,000,001 ways that only they know.
It only takes the raising of an eyebrow, doesn't it?
The whole thing is a complete waste of time. And exactly that. And courts know that. They're very good at, thou shalt not. But they're limited in saying, and please, will you just smile when you hand the children over, and even if you don't want to? Will you please not put everything on Facebook or, because the children carry this burden, and the evidence is there. The mental health is off the scale with CAMHS. Children, when you talk to them, and I talk to them a lot as a CAFCAS officer, they were always preoccupied with, please, will they be friends? Please, will you make parents be nice to each other?
Yeah.
They will do anything. And if you think about it, the children share the load. They do the donkey work. They move from, this place to that place. I mean, we know ourselves, don't we, when we have to move around a lot for work. It's unsettling, isn't it? I mean, this hotel, that hotel. They're doing that, and they'll do it mostly with a willing heart, but they need backup, and the backup they want is...
as you're speaking there, Monica, about the children's expression of their wishes and feelings to you as a CAFCAS officer, and it's so much about they would like their mum and dad just to be friends, to be nice to each other. And then it takes me back to when the proceedings start and the building blocks are put in place and parents make statements. What impact do you think that those statements will have? Because they often want to unburden themselves of years and years of unhappiness or bitterness or recrimination.
Well, it's very difficult for the children because, and it's very difficult for the adults as well. I sympathise. And there's always something about what I would say is the power of the written word is huge. People can sometimes, again, I think it's sometimes I'm plugging mediation mercilessly, and I qualify that by saying it isn't for everybody. There are some cases that are most certainly not. But it's often easier to resolve a dispute when there isn't copious amounts of written statements and arguments and solicitors' letters, because it just fires people up, and the power of it is tremendous. And sometimes people can say far worse face to face, and you can unpick it and say, well, can we find another way around this, or acknowledge the feeling, move it on. The other person has an opportunity in real time to say, I didn't intend that. That was never my, and it's gone in a moment.
Yes.
But if delay, and lots, which there is inevitably in proceedings, and the power of the written word, people go back to it and they ruminate over it, and they, it's human nature.
Yes. We often say things that are said can't be unsaid. But things that are written down have an even more lasting impact. So it seems to me that's a message not just to lay people, but also to their representatives, that care should be taken about what exactly is put into writing, what's said. I sometimes think that a useful filter would be, how would I feel if my children read this a little bit down the line?
I think as well, in fairness, sometimes, solicitors' letters come and clients receive them and they're furious. And then you look at it and you say, well, actually, that's very standard. Then read it again. They're not really accusing you of that at all. This is all part of them. This is the reason why they do it this way. But I tell you another thing that sometimes I see with the letter writing is that the clients may have had a row. They might come to mediation. They've sorted it out and they're on, a better pathway. But, the week before, they've both been to see their solicitors and, told them what they thought. But because of the delay and the post and the letter, then the letter drops after we've resolved it. What's all this? And off we go again. Yeah. So sometimes it's least said, soon is mended, I think.
One of the things that, if you read the law or look at how family law is described by lawyers, it's said that it's inquisitorial as opposed to criminal law or civil disputes which are adversarial. What's your view on that, Monica, having been involved for so long?
I think that very much depends on the people involved, both the professionals and the clients involved. Yeah. I think that's quite a hard question to answer fairly, because no two cases are ever quite the same, because judges have huge discretion as to how they might wish to resolve matters. CAFCAS officers have very, very different ideas sometimes about how things should be resolved. And over time, fashions change. I mean, they change within the court system. Yeah. It used to be, when I first practiced, just as one example comes to mind, when I first practiced many years ago as a CAFCAS officer, that courts or judges would be very reluctant to do a shared care order, because one of the arguments that they would put forward is they would say, we know if we're looking at it through the lens of what's in the best interests of the child, that the child needs to have parents who will work cooperatively in a spirit of cooperation. Yeah. And the very fact that they before me tells me everything I need to know, that these two will work in an adversarial way and they will place their children in an impossible position. So no, before they've even made their submissions.
Yeah, just the very
fact that they're there. But of course, circumstances have changed, family dynamics, family patterns have changed, and that's moved on significantly. And shared care is very commonplace,
yes. Even the way in which people's work and home lives are organised now. It used to be the case that the traditional arrangement was the husband was the primary breadwinner, the wife was the homemaker. So just availability meant that men, I'm generalising, tended not to be available for all of those parental duties. Of course, that now has changed
hugely and beyond recognition. And of course, factor into that, people work shifts. Most, as you say, both parents are working, and then you have children of other relationships. So when you're working out contact times and patterns, you're factoring all these. It can be quite complicated.
Tell me, in your experience, do you think that the courts and social work professionals have caught up with that? Because I have recent experience where the shared care arrangement has been ruled out because it requires parents to be on the same page and to be able to work together. And it surprised me that that's still a view that's being held by both court and CAFCA.
I think it's more complex than that, because if you track back, think about it, the court's sole consideration really is what is in the best interests of the child. So they will resist an assumption that we divvy children up like chattels, right, it's half yours, half mine, half the other person's, because we're looking at this through the lens always of what is in the best interests of the child. And no two children will be the same, and they may have complex needs. There may be different parents may be able to offer more. Some may do one aspect of care, the other not so much. There may be geographical distances between the two of them, and actually it would, if you took a very absolutist approach on that, it may well be to the detriment of the child, because they would have to pay the price. And,
as we say,
practically, you have to.
As we say in family law, each case is determined on its own particular facts, and each case has to have regard to the welfare of each individual child.
Yes.
So essentially, we don't have a one-size-fits-all solution to cases.
And I don't think we ever can, really, if we are going to honour what's in the best interest of the child. So I think you kind of come back full circle.
I'd like to come back to that in a second, because I'd like to ask you about what parents should expect if they're going into the family justice system. But before we do that, you made use of what's an old-fashioned word, chattels, our belongings and possessions. And sometimes parents behave as though their children are possessions, that they own their children. And of course, we know that our children are just lent to us.
Yes.
But the point I'd like to just raise with you now is that in family law, in particular children cases, parents are told often by judges and social workers, I'm not interested in the financial arrangements. I'm just interested in the welfare of the child. Whereas a parent might say, and this has happened to me on many occasions, here am I'm left struggling in a one-bedroom flat with 2 children, and he's living in a 4-bedroomed house with a big garden and his new, well, they might not always say it in the nicest way, his new partner, and they're going on holidays, and I'm expected to encourage my children to think that they should be going to see the father and be happy about it. Do you think it's reasonable for the court or for social workers to say that actually the money side of it doesn't matter, it's immaterial?
Well, I understand the rationale why the court does do that, because they are, again, it's back to this principle that they are there to look at what's in the best interests of the children, and what they say is there should not be a price put on the head of this child's right. And I talk about the child's right. Parents often think they have rights. They don't. They have responsibilities in law. It is the child who has the right to have a meaningful relationship with both parties. That said, Mike, I do sympathise with some of those arguments, because, it's more complicated than that for parents, isn't it? And it is very difficult because finances are crucial, and in a divorce, it is a bit like a bereavement, and it has all the same impacts, or can often have the same impact. So at Manchester and Cheshire Mediation, we also offer financial mediation as well, and that way we can offer people an opportunity to look at it in a more holistic way. Because, again, going back to children have a sense of fair play, and they're compromised, because don't forget, they often love both parents very, very dearly, and they don't like to see that imbalance. And it's a bit of an own goal sometimes if parents don't do the right thing by the other person. And so that can come back to haunt them at a later date. But being able to have an opportunity to sit down and look at what is possible and how else you might resolve these things, how you might resolve the finances. Because, I mean, take back to our previous example. Let's say you have a shared care arrangement, and let's say both parents are relying on the other parent to look after the children because nursery fees are so expensive these days. Well, it's simply not going to work if one person ends up in the caravan and the other person and can't accommodate the children, and the other person is living in the mansion. Because I know I'm using ridiculous extremes here, but you know, they need to work in a collaborative way, if only for their own well-being, to make the whole thing work.
I mean, if just for the sake of balance, we looked at it the other way, and you have a father who says, I'm paying £10,000 a month to my ex and the children, and I'm only allowed to have one afternoon a month supervised. It's not fair. You can understand the mindset.
Indeed you can, and that is a very valid argument. Likewise, you can flip that on its head, and if you go down that road, which is why the courts are so keen not to allow that to happen, you could get a person saying, give me £11,000 a month and you can see your children. And straight away you're in a sort of semi-hostage situation. So the court, I think, with the best of intentions, but it doesn't always play out that way, tries to remove the money, the price tag, out of away from the principle of these children's right and entitlement to have a meaningful relationship with both parents, unless there is good reason, cogent reasons, they say. I mean, good reasons why not. And when they say good reason why not, they're talking serious, heavy end, serious domestic violence, child protection, risk of harm, serious emotional abuse. And sometimes being able to talk to people early on in the process and say, look, you know, it's not for us to say nobody can promise you anything, but, you know, typically case law would say this. So a judge is not going to be sympathetic with this argument or that argument.
That's a very interesting point you make, that if very early on in the proceedings, either a court were to say, or an advisor were to say, or an independent social work professional like you were to say to the parties, when you're separating, you must appreciate that if you don't have fairness in the division of your assets, then you're kidding yourself if you think it may not have an impact later on over the children.
Yeah, sure.
But we steer clear of saying that because we've got so used to saying the two things are completely separate.
Yes.
And in real life,
they're not.
They're not.
They're not. They're very much intertwined, I think.
Just going back to the point before that little diversion, I'd be interested to know if you were to just encapsulate advice you'd give to parents who are either embarking on this or who are listening here, who are thinking, this might be me in a few months' time. What sort of guidance would you give them? I'm going to stress that we're not giving formal advice here, but it's just words of guidance.
Well, I would say I would explore the option of mediation, because if it's very hard once you start on a litigious route to then row back and say, it's a bit like when a war starts, isn't it? And somebody comes on and says, well, let's all stop this now. Let's just have a nice chat. It's very hard for people to take up those positions once they've committed themselves. Whereas if you start at the beginning and say, well, let's see what we can do here. At least we've explored it. If it doesn't work, fine, off you go. But don't automatically rule it out. So I would say have a look at the mediation options. The government is really getting behind it at the moment, and they are offering vouchers for people where there is an element of children's matters, both for finances and for children. So, that should be available. Some mediation practices still offer legal aid, although they are few and far between. But I think it's a good place to start.
Yeah. And I think, Monica, that most reputable family law practices do encourage clients
absolutely
to look towards mediation as a starting point. And in fact, as we both know, the family procedure rules and the forms that people have to fill out require people to have attended at least one mediation session.
That's absolutely right, Mike. And also what people don't realise is that mediators, lots of solicitors are mediators, lots of judges are mediators, lots of barristers are mediators, lots of former CAFCAS officers. Just as a mediator, you're not acting in that capacity, but clearly one would hope that you don't forget your experience and training, and so you can bring that to the mediation forum and in such a way as the neutral in the room. So you're there to say, look, I'm giving you this as information. I don't have any axe to grind with either. I'm not on anybody's side. Do with it as you will. Do with the information, but good data, good decision making. And if don't take my word for it, please don't. Go and check it out. Go and ask intelligent questions. Be curious. Talk to your family if you're not comfortable about certain things or you're uncertain. But be informed. Don't be ignorant and go into this system, because once you're in it, it's very, very hard to row back.
I think one of the things that people want to know is, what can I expect from this process when I get into it? And you're a slightly more detached observer than me as a lawyer, who will want to try and do that. But looking at things from a neutral position, what would you say people should be expecting?
Are you meaning what they would expect in a sort of typical mediation setting, or in a court setting?
Say we've gone through the advice that initially you should look towards mediation, but say that doesn't work. What and we can come back to mediation, but what should they expect when they actually go to court?
Well, I think court times or timing is very variable. They're under tremendous pressure, so there are long waiting lists. So they will first of all they have to go and see a mediator. If they don't wish to mediate, and they have to get a form from us, which we have to sign off. They have to activate that within 4 months of receiving it. They may well be challenged at that point when they get to court by a judge, who will look at it and say, well, there's clearly no reason why you can't mediate. And they may put pressure on them to come back. I mean, don't forget, mediation is voluntary, so they can't make them, but they can make life a bit difficult. Let's say, we're agreed that mediation is not suitable for whatever reason. Then they may or may not get a CAFCAS officer. The rules around when they appoint CAFCAS officers have changed. Again, like all public funded services, they are under huge pressure.
And just to clarify, the CAFCAS officer's duties will be to investigate, assess, and sometimes make a recommendation.
Nearly always make a recommendation as to what they think is in the best interest of the child. The role of the CAFCAS officer in that setting is very influential for a judge. Because, as I referred to earlier, they're the only independent person in the room. So the judge, their evidence weighs heavy on a judge, and it is often grounds for appeal if a judge were to go against their CAFCAS officer or guardian.
And say,
they don't want to be appealed.
No one wants to.
No one wants to be appealed.
Say, you're the CAFCAS officer, and you see the parents, and the mother says that I've tried to encourage the child to go and see father, but they just won't do that. And the father gives you a long diatribe about how the mother is poisoning the child's mind against him. And you've then, on the basis of probably a couple of interviews and maybe an interview with the child, depending on their age, have got to make a recommendation. How do you deal with that situation?
It is really difficult, but I think, taking into account the age of the child, the way that the following on from the interview with the child, I think there are certain ways and certain questions that one learns to ask children to try and ascertain whether or not there is undue influence. Yeah. And sometimes parents are not aware that they're doing it. Yeah. Quite often they're not aware that they're doing it. And also, what you've also got to bear in mind is that, the parents are in charge, or at least they should be. They're the ones that should be deciding. I mean, you can't really, of course you have to listen to what children, that is really, really important. But, 5-year-olds making decisions about whether they're going to have a relationship with somebody, they're still believing in Father Christmas. I mean, you've got to take into account their age, their ability, their so on and so forth.
I've given you that scenario because it's one that
it's very complex.
It's very, very common.
It's also very, very common that children, even older children, and I have seen this with my own eyes, have absolutely, thrown hissy fits. They won't go. It's not going. No, this, that, and the other. And then something happens, or the issue is say forced, but made to happen, and then that's all forgotten about. Yeah. And also, I would say, these are all the caveats that you kind of have to bear in mind. Children, it is not unheard of, and those of us who have had children, teenage children and teenage children, that, their histories can sometimes change. Yes. And memories get changed. And children have been known to say, well, why were you listening to me? You didn't consult me whether I wanted to go to school or not. I went. Because you said I had to, I didn't want to. And now you've changed the course of my relationship with my parent. And so, and it's a very hard one for parents. And sometimes there are genuine reasons why children don't want to go, shouldn't go. But I think the court and the professionals are very reluctant to give in to that too quickly. Yeah. For the reasons I've explained.
Just staying with the theme on what the parent can expect. If a case goes down this route of one parent saying, oh, the child doesn't want to go, the other parent saying that the other one is either encouraging or fabricating a story or alienating the child, if those cases can't be resolved by the intervention of CAFCAS or a court giving some direction, they are the cases which can last for months,
forever,
years. Mm-hmm. And I'd be interested to hear your views, maybe from cases that you've been involved in, anonymised, of course, on the impact on the children of being caught up in the middle of that, but also on the parents of being caught up in that sort of situation.
Sure. And it's tragic for all concerned, because it's so hard for children. It really is hard for children, because I know this sounds, you may not believe me with this, but they nearly always say the same thing to CAFCAS officers whether they're little ones or big ones. Yeah. They want the conflict to end. And conflict comes in many guises. They can be the plate throwers, and then they can be the golden silence people who use the children as the sort of mini messengers to pass the message, tell your dad this, tell your mum that. And the children do it, but they're burdened by it hugely. Yeah. And I think it does have a very lasting effect. I think it depends again on the child, because we're all different, and some children are more vulnerable, they're not as robust, they get very anxious, they think they're going to say the wrong thing. What they tend to do, children, when they're under that influence, is they have a number of strategies, and they're quite simple, and when I explain them to you, you'll think, yeah, I get it. That one of the strategies they have is they say, and often this is very subconscious, this is so awful. Every time I go, there's a row, there's a fallout, there's an atmosphere. When I go, when I come back, I can't bear it. And I'm having to do it on a regular basis. Yeah. And not only the parents, we've got the family and the friends and everybody else is tutting and rolling their eyes, or not. Or I imagine they are. So do you know what? I'm just going to have to pick my parent.
Yeah.
And I'll pick my parent because I can't stand the pressure of this. So they pick the parent, and then time goes on, and then sometimes they flip and they go and they pick the other parent, and then they're flipping between the two. That's not good. A common strategy that children adopt, and these are all strategies to protect themselves from this level of conflict, is that they do what we call, they tend to compartmentalise. So what they do is they learn to live with one household, with one parent, and they have a lovely time, and by and large all things are, as things can be with. Yeah. And then they go to the other parent and they do the same. But if the parents try and inquire of the child what's happening, they'll clam up, they won't share information, or they'll be very, very careful about what they say for good reason, or they will find the changeover very hard. So you often get parents complaining, or when they came back from there, and that some of that might also to do with the transition. It's a trigger for them. It's like a bereavement. Yeah. So that's common.
We're often told these days that we've got a crisis in mental health. You're probably in a good position to comment on that, because you see a lot of different people in different situations. Do you think that family disputes can be a contributor to
Absolutely. I think it's massive. Yeah. I think it is really massive, because if you think about it, we've all had experience, I'm sure, where you might have had a fallout with a friend or a relative or something, but you as an adult can make choices. You can decide how you deal with that. Children cannot. They have to live it. So they can't walk away and say, a plague on both your houses, I'm not joining in anymore. Yeah. So they have to manage it. And this is something which I think it's no respecter of class, age, intelligence, money. It's not something you can buy your way out of. You can't throw money at it. What they want is loving permission to move between the people that they love. Yeah. And they want support with that. So they want the war over, and they will do the hard work, because they are doing a lot, and the parents are doing the hard work as well, but they sometimes forget the children are doing a bit of hard work too, because they didn't ask for any of this. It happened, and it happens, that's no blame or recrimination in any way. But
one of the ironies that I often think is that if you were to ask each parent why they were doing what they were doing, well, I'm going to say, what do you think the answer would be?
Well, they would always say they're doing it in the best interest of the child. Yeah. Yes, that's what you were going to expect me to say.
Yeah.
Yes,
and that's
exactly.
That's what they always say, isn't it? And I sometimes think, well, and I do try and have this conversation with my own clients if I feel that they perhaps being unreasonable. But I sometimes think if there were to be an element of the court service or CAFCAS or children's services which was there to provide parents with information, with education and scenarios where they could say, here's a child who's been in the situation that your child is about to go into or is in the middle of, and here's the impact on that child in terms of their, forget about mental health, but just contentment, their ability to concentrate at school, their ability to form and keep friends,
relationships,
the ability in future to have long-term happy relationships, their drug use or alcohol use. Do you think? Well, I think you'll agree with me. To be a good idea.
It would be a great idea.
Why hasn't it happened?
I think there's been various attempts with, parenting courses and all the rest of it that the government that the courts use. I think the difficulty sometimes is that whether people are ready to listen. It's always, that was them. This is not. It's not my case. It's not my child. Some do, some don't. You don't always know when you say these things whether they land or whether you plant a seed or.
And I think we as professionals are so anxious to let people know that they're unique. It's their case, and not to say, you know what, I've seen this hundreds of times. I've seen you and your ex and your children hundreds of times, and this is what's going to happen, this is what is happening, and this is what you're doing. We're a bit reluctant to say those things in such blunt terms, aren't we?
I think so. I think I don't underestimate how hard this is for parents, though. It is really difficult. And it's sometimes perhaps not so helpful for professionals to say what you shouldn't be doing. It's more maybe what you should be doing. And what might be more helpful is, right, well, let's have a look at it where you take parents where this doesn't happen. What is it that they're doing that works so well? Because that you don't have to like each other post-separation. You just have to, I say just, that's a big just, have to find a mechanism, a way of working, and, fake it till you make it. Get your Oscar-winning performance, but you would do it for your children because, you're only as happy as your least happy child. Yeah. And all I can keep repeating is that if you are genuinely listening,
that's a really good expression. I've not heard that before.
So you're all tied up in it, your happiness, their happiness, but can't say it enough. Children often have a very different agenda to their parents, and parents don't see that. Yeah, the children are very preoccupied with the atmospheres. And they'll drop a day, or, they'll switch it round, they'll inconvenience themselves, say, please, can there not be a row, please? Yeah. The parents are obsessed almost with quantum.
I was going to say the number of times that people are in contact with their solicitors about, I lost a day, say they're ringing you in November, I lost a day in June, and I want to get it back before Christmas. Mm-hmm. What would you say to a parent who, give me carte blanche to say what I should be saying to a parent who rings me up with that sort of query?
I think let it go. I think you've got way more important things to be focusing on. Obviously, if you keep missing days, that's a different story. But don't sweat the small stuff. Pick your battles. Pick your battles and learn to take a deep breath and smile through it, because there's something else going on here, and your children are watching you very carefully. And even little children are super sensitive to this stuff. They are very, very alert to what's going on.
So it's more about, well, you were saying before, it's more about quality.
Yes, absolutely.
Making contact time a happy, secure. It doesn't always have to be happy and doing fun things. It's that sense of routine, security, consistency.
I also think, and we try and encourage parents to do this, is that if they can bring themselves in a managed way, and it might have to be managed just because that's the only way it can start, is to have maybe a phone call once a week, time limited, where they can share information. So they're not doing this parallel parenting business. They can share information in a positive way about what they've been doing their side. You know, I mean, it's perfectly logical if you think about it. You wouldn't dream of sending your children to school and say, well, I'm not talking to that teacher, you know, I don't want to know what's going on. So it is a logic to it. But, you know, I accept that there's sometimes a lot of stuff's gone on. But if they can bring themselves to have that conversation, because that in turn, they can feed that back to the children. Oh, you know, I was talking to your dad about when you went swimming and you did. That gives so many positive messages that the child is then, phew, you know, I don't have to. If
they could,
they know that they are behind the scenes working it.
And if a child can be relaxed about sharing a happy time they spent with mum, with dad, and vice versa, because what's more anxiety provoking than not knowing whether you can say I'm happy with that person because it'll upset the other person.
Yeah.
That's excruciating, really.
We always think, don't we, that as parents that we look after our children, which indeed we do, or one would hope we would. But actually, parents do forget children look after parents. And they worry about them and their well-being, and they will sacrifice themselves and their feelings to make their parents happy. So they will say what they think their parent wants them to hear. And that was always a big problem in CAFCAS. It was always very difficult to distinguish, but it came up a lot.
There are cases where we're describing the case where for sake of argument, the child is with one parent. Say the child is with the father, and the child's refusing to see the mother, and there's appears to be no obvious reason. At what point do you, as a CAFCAS officer or a social worker, say, this is now so serious, the impact on this child is so serious that the court should be investigating it further about, you know, is it right the child should remain in this situation?
Well, of course, as you know, and it does happen in those extreme cases, and the court is right to investigate that, because you can't allow a situation not to go uninvestigated. And if there is a situation where somebody is willfully holding back a child and not permitting them to have a relationship, well, if the court isn't going to do something about that, then why is it there? It has to have those powers, and they don't happen very often. Well,
but the reason I'm asking you this is that it does happen.
It does.
And it often happens where the parent who has the child living with them seems so convinced that they're operating in the best interests of the child that they can't even contemplate that they might be causing harm. And then this terrible bombshell hits them. The judge has said to Children's Services, I'd like you to investigate with a view to possibly removing the child
I have known
from that parent.
Yeah.
And then if they go to the other parent, you will only have very limited and possibly supervised contact with the child. Now, my own experience is these parents never imagine that could be the outcome.
Never imagine, and they forget that a judge has tremendous power. They don't always use it, but absolutely they can, and sometimes they do. Say, well, back to this principle that we have, what is in the best interest of the child? It's written in law here, black and white. Child have a meaningful relationship with both parents, unless there's reason why not. We've established there's no good reason why this child can't have a relationship, but for the fact that one parent is preventing it. Well, it follows, doesn't it? What are you going to do about it then? You're going to have to tackle that. So their options are either they change residence to the other parent, that's an option, or they threaten the parent with prison. They can do that. I've known that. That's more common than people like to imagine. Or they say this child will be going into temporary foster care while we investigate further. So all of those options do happen, and they're not just one-offs, so, as you know, Mike.
Yes, so I do. And the thing is, we know, but members of the public don't know about it. And it's perhaps something they should be aware of before they embark on this process.
But it's back to that principle at the beginning where you say to people there is only one of two ways. And if you can be encouraged and helped and assisted to see if you can find a way to do it yourselves, and working in a very bespoke way, it might work, it might not. Or you go down the court route. But if you go down the court route, and it might be that the court is the best place to go because somebody needs to make a decision.
Of course.
We've all had a go at it and we're not getting anywhere. And that somebody is the judge. And they will make their decision and that will be final. But don't forget that the judge has tremendous power and can and will do what she thinks is fit.
Just coming to another element, which is taking into account your experience over the years, if there were two or three things that you could change about the system, what would they be, or even just one?
I would like to see proper funding and encouragement of mediation early doors. The government's giving some money, but it's a drop in the ocean, and it's a fraction of what people would pay at court. Absolute, fraction. I would suggest that this is probably more applicable to finances, but it all ties in together with court time, which is so precious, that they should seriously consider a weighting system, financial for court fees. So in a very high net worth value financial case, that they should adjust the fees accordingly, and they should reward people who come to a consent quickly by waiving the fees. So more carrot, less stick, and fund the alternatives, the preventative stuff, early doors, and then make the court system pay for it. I would also, I would promote that, and that's not just because I'm a mediator. I truly do believe, I've seen it both sides, that if you can save yourself from it all, you will never know what you have saved yourself. But trust me, I'm a mediator. One of
my regrets is that there isn't any legal aid now for private law disputes between private individuals. Of course, there is legal aid for cases where children are being removed by local authority in care proceedings. It seems to me that taking that away from individuals, because people don't realise that a lot of cases are resolved before they go to court
Yes.
by sensitive advice and guidance from solicitors
Yeah,
as
of
well
course.
as
Yeah,
mediators.
absolutely.
That's meant that the courts have ended up with cases unnecessarily going before them
Yes.
because people haven't been given sensible advice and guidance. And it wasn't a huge amount. Apparently, the government were saving something like £250 million, which in terms of the budgets that they have is tiny. I'm sure the same thing goes for mediation, that a relatively small amount would go a long, long way.
A long, long way. And we're all talking, it's the same dog, more hair. We're all talking the same language stuff. We're just coming at it under different legal rules and in a different way earlier on. It just, if it can be done earlier on, it's quicker, cheaper and easier. And then you save the court time for the urgent stuff that needs to be dealt with. And save everybody a bit from themselves, because you know, when you're in free fall panic, you haven't seen your children for 4 weeks and the other person's not cooperating. I get it. You know, you want action. And you go and pay and do anything. You're a bit of a hostage to fortune in that sense. So, you know, people are very, very vulnerable. So they need somebody to get in there quickly.
One of the other things that I think has changed over the years that we've been involved in this system is that CAFCAS officers, court welfare officers, used to have an awful lot more time to spend with the parents and the children. And so the advice and the recommendations they could give to the court were much better informed.
I'd agree. I think... well, you know, I haven't practiced for some time as a CAFCAS officer, but I still have my ear to the ground. But back in the day, we would home visit, and there is no substitute really for sometimes going and seeing with your own eyes what the setting is, how children are living, being looked after, what they're saying, and they're more relaxed in their own environment, and you pick up other things. It's sort of good old-fashioned social work, really, eyes and ears stuff. All that's gone. They're all cut to the bone. You know, they're on a treadmill, and it's a loadly, hard, tough task. And I don't envy their brief by any means.
But it seems to me that it's compounded by the fact that judges have less and less time to deal with each case, and therefore the importance of having a very detailed, well-informed CAFCAS report is even greater. So parents and children are losing out on both sides there. That there's a huge pressure on CAFCAS to settle cases quickly, on judges telling clients that they need to be settled quickly. And if they can't agree, then they have to wait an awful long time to get a hearing, which isn't always an effective hearing. It might be a directions hearing. So resources
again, and also they've got problems with recruitment, you know, and working as a CAFCAS officer is very much a sort of it's a career that one comes to after you've cut your teeth some years in another area of social work. And it takes a long time to hone those skills as well, because, as we identified before, every case is slightly different. So you have to be 2 or 3 years before you've seen it all come round once again.
One of the things that clients sometimes say is, what's going to happen? And I have to say, I really don't know. I can tell you what I think should happen, and being objective, I'm not just being on your side, but each CAFCAS officer is different, each judge is different, and the representation on the other side is different. So going into the family justice system is a bit like spinning a roulette wheel, isn't it? It is.
And it is, of course, as you know, Mike, the first question you ask when you're going into a contested hearing as a solicitor invariably will be, who's the judge? Who's the judge? Who's the GAFCAS officer? Who's so? And you might well, there and then, on the spot, correct me if I'm wrong, change your advice. Or modify your advice, shall we say, not change your advice, but modify
in my own
expectations.
Defense, I won't change my advice, but I may say to the client, I may need to approach this in a slightly different way and be prepared for A, B and C.
Yeah, I think it's, not advice, change expectations or be aware that, we might not be.
Yeah. Right, well,
okay.
I think that the end of that, Monica, and thank you so much for being a guest, is go to mediation.
Yes.
So, we're happy to be to give you a little bit of a blurb
Manchester
here.
and Cheshire, we'll look forward to seeing you.
And just know that going to court is risky, it's unpredictable, and if you possibly can, using my example before, there's the door.
Yes.
You can go out of it. Anyway, this has been another episode of Opening the Door to Family Law. It's been great to speak to you, Monica, and thank you all for listening or watching or however you've been consuming this podcast.
And thank you for inviting me.
You're welcome.
Yeah, bye-bye.
Okay, bye.